Good evening and welcome to another edition of Law and Order, brought to you exclusively by Channel I. As you are aware, my dear viewer, the objective of this show is to educate you on matters which are of relevance to your day-to-day lives, but we will be looking at it from a legal perspective. So in other words, we take a topic each week and we look at it from the perspective of how the legal aspects of these various issues you might face would impact you and how you can respond to in these situations. And tonight we are going to tackle an extremely important topic, and that is the question of inheritance. We all know that we can own property in many ways. We can either purchase property or we can be gifted property, but one of these ways in which we can become an owner of some form of property is through inheritance. And tonight, to look deeper into this topic, we have with us an attorney at law, Ms. Soumya Amarasekara, who counts more than 30 years in the profession and who is highly respected and whose advice has been sought particularly in this area of law. Thank you, madam, for taking time off your busy schedule to be with us tonight. It is always a pleasure to engage you on these areas of law. For the benefit of our viewers, shall we just really go down to the rudimentary aspects of inheritance? Can we just first and foremost just talk about what inheritance is?
Inheritance is what a person would acquire after the death of a relative or a friend or some associate. Basically, that is it.
After someone dies,
yes,
what you
get after death of a person.
And madam, how does the law come into play? Why is it important for us to know what the law has to say about how we inherit property?
Basically, with regard to acquiring property, as you mentioned earlier, the well-known principles are by gifts, by transfer, but the law has to come in, otherwise after a person's death there can be many ways in which people can claim. There can be many claimants. So, unless there is some law to regulate it, there will be utter confusion as to who gets the properties or how it should devolve on the people living. And sometimes it is not only the relations who are entitled to properties, there are like the state is entitled to recover taxes, the creditors are entitled to recover monies due to them from the deceased. So, you have to go through courts in order to sort out all the claims on the estate of the dead person, otherwise there will be unresolved issues.
I see. And with respect to now say for example, someone passes away and he has wife and children, his heirs, his wife and his children, what regime of law do they come under? Is there a specific area or different types of laws?
Yes, generally if you die leaving a last will, then the property will be distributed. Property, all the assets of the deceased will be distributed according to his wishes as set out in a last will. However, the problem arises if there is no last will. Then we have what is known as the Matrimonial Rights and Inheritance Ordinance, which generally applies to the whole country. That says how the property should devolve and how it should devolve. Of course, there are with regard to the people in the northern province, there is Tesavalame. Then the Kandyan province, you get the Kandyan law. Then for Muslims, the Muslim law. So, if you belong to any one of those sectors, they also have very well defined laws as to how the inheritance applies.
Of course, we do not have time to go into these different types of law.
Each area is highly complicated. Yes. Those are known as personal laws, personal to the people of those sectors. Those are very complicated. but the general Matrimonial Rights and Inheritance Ordinance has simplified it for the rest of the country, and it's set out in that statute, and it's pretty straightforward.
So, once someone passes away, after an individual's death, all his property is what is referred to as his estate. So, his heirs, once that individual has died, what should they do to ensure that that his inheritance is devolved on his heirs in the manner he wanted it to be devolved on them?
Okay, it is done in two ways. Now, if a person dies a last will, there is one procedure to be followed. If a person dies without a last will, then if we apply the Matrimonial Rights and Inheritance Ordinance, generally the property will devolve, say if it is a married person, half will go to the spouse if the spouse is still alive, and the other half will go to the children. If there is no spouse, the whole estate will go to the children. If there are no children, or if a child is dead, it will go to the grandchildren or to the grandchild of that particular child. So, basically when it comes to intestate succession, when a person dies, first it goes to the descendants, that is children, grandchildren. If there are no children or grandchildren, it goes to the ascendants. That means the parents of the deceased person. So, if one parent is alive, the dead parent's shares go to the brothers and sisters from that parent. If both parents are deceased, then it goes to the brothers and sisters.
So, the half goes to the wife and the other half to the children or the descendants, but in the manner that you stated just now, if there are no children, then the grandchildren, and then if not, the ascendants and so on and so forth, and thereafter the brothers and sisters.
Though there are like quite a few variations from that, but generally it goes as descendants, ascendants and collaterals, that is the brothers and sisters.
Okay. Now, if there is a last will, how does that take place?
The last will is of course the wish of the testator, that is the dead person leaves specific instructions as to how he wants his property or her property distributed. So, then it goes strictly according to the instructions, even if there are children or if there are grandchildren, if there are spouses, if the dead person did not wish any of them to inherit, he can give it to any person he chooses. So, if there is a last will, none of these laws apply, it goes strictly according to the wishes of the dead person. He can give it to a complete stranger, he can give it to a charity. So, that is, it is his prerogative.
Madam, if an individual wishes to, has an idea of how he would like his property to be distributed after his death, then he would obviously have to write a last will.
Yes.
What are the necessary requisites of a last will, and how does one ensure that that last will is legally enforceable?
So, generally there are two types of last will. That one is known as the 5 witness will, that is the person who is making the will can write or type out whatever he wishes, and he can sign it in the presence of any 5 witnesses. Of course, none of those witnesses should be a beneficiary to the will. It does not invalidate the will, but then that person will not be able to get the benefit from the will. So, the 5 witness will is you can sign in front of 5 witnesses, and all the witnesses must be present at the time the person making the will signs. Then all of them must sign in the presence of each other. The other type is where you go before a notary and 2 witnesses. So, there the notary will most probably prepare the will, not necessarily, but he must witness the attestation of the person making the will, and it must also be witnessed by 2 witnesses. So, generally those are the things that have to be observed, but all parties must be present or must be aware that the person making the will is in fact putting that person's signature to the last will.
I see. If we look at, once again, if we go to inheritance in the other way, without a last will, say someone dies intestate, is there anything more that the heirs need to do? Is it necessary to file action and seek the assistance of court?
Yes, generally if the person who dies leave assets which is over 4 million in value, then it is compulsory for you to go to court, file testamentary proceedings and administer the estate through courts. Otherwise, it is not compulsory for you to go. So, the principle is unless you go before court and get the estate administered, you are not free to deal with immovable property. If you want to deal with immovable property of a person without going to court, then you can't legally deal with it for a period of at least 5 years.
5 years.
So, it is best that you go to court immediately after death, if the value is over 4 million, and get the court to administer the property. One of the reasons why you are compelled to go before court is the court has the responsibility to ensure that if there are any monies due to the state, like such as taxes, all that is recovered before the estate is distributed among the heirs. So, the first claim is to the state. So, once that has to be settled, then all the creditors to whom the deceased person owed money, all that has to be settled. And once all that is done, only the heirs are entitled to get the properties. Yes.
Madam, who in these circumstances should file action? Do all the heirs have to file action, or is it just, for example, only the wife? Who exactly should seek the assistance of court?
Now, if a person dies without a will, anybody who has a claim to the estate can go to court. So, generally it can be the spouse, or it can be one of the children. If there are no children, as I said, parents, grandparents, but they must be people who are getting a right from the deceased, or a creditor can go. Supposing the family does not file a testamentary proceeding, a creditor can go to court and file a testamentary case and claim the monies that are due to him.
Now, are there instances where someone can object to these heirs, those who have come to court and are seeking the assistance of court to have the estate of the deceased administered? Does anybody else have a right to object to it?
Yes, sometimes there are cases where people object. Sometimes if you go to court on the basis that the person has died without a will, somebody can come and say, no, in fact, he had left a last will and therefore you can't get it. Or another person might come and say, even though you are claiming to be an heir of the deceased, you are actually not an heir.
I see.
So, like say for instance, if a man has illegitimate children, they have no claim to the property. So, if one of those children files, somebody can come and say,
I am the actual child.
You are illegitimate, you have no rights. Or sometimes a person might come forward and say the spouse is not actually the spouse. He was either married before and not divorced, or that the marriage is not valid. So, there are many ways in which a person can object to letters of administration being granted to someone. Also, but generally if you just object saying, I do not think the wife is a suitable person, she does not know how to handle affairs or things like that, in those circumstances generally courts favor granting letters to a spouse or to a child. So, generally there is a presumption, rather than giving it to a creditor or to some other person, the first choice would normally be the widow or widower of the person and then children.
You said you used the words letters of administration, madam. What are letters of administration?
Okay, sorry, I got ahead of myself.
That's right.
So, generally when you go to court and says a particular person is dead, he has left all these assets and we are the legitimate heirs and distribute it among ourselves. The court has to appoint a person to carry out all these functions. So, the person who is appointed by court is called the administrator. So, in order for that person to function, court issues what is called letters of administration. It is a document authorizing that person to look into the estate of the deceased. So, with these letters they can go to banks and find out the monies that are that belong to the deceased. They have to deal with income tax. They have the right to get all the information with regard to the estate, and then they are also entitled to settle debts, get permission of court and sell properties if necessary.
Pending the case.
Yes, pending the case, to settle the debts. Basically, that is the person who will be responsible for gathering all the assets, finding out what the assets are, also to find out what the liabilities are, and to sort it all out and distribute the balance among the heirs.
So, it is a grave responsibility, isn't it?
Yes, it's a grave responsibility, and there are many, the law provides that if a person does not act properly, that person can be removed from the post, that person can be held liable. So, it's a very responsible job.
Madam, if there is an individual who owns property all over the country, and the administrator's duty is to locate all these different properties and the extent and so on and so forth, or say that the deceased has various accounts in different banks and so on and so forth, and the administrator is finding it difficult to do so, will court assist the administrator in any way?
The administrator has many powers. You can, if you are not sure whether the person has particular issues, accounts with banks and all, you can summon, or you can write to the administrator, can write to those banks and ask for information. If those institutions are not forthcoming, you can summon them to court, and with the assistance of court, they will have to answer to court as to the accounts that were there, or whether there were no accounts, and if there are accounts, the money is lying to it. And similarly, even from other institutions, you can make all these inquiries, and if those institutions are not helpful, you can call them to court and obtain the information through courts.
And after, is there a particular time period within which someone needs to come to court after the person dies, or can they wait any number of years?
The rule is that you must come to court within 3 months after a person's death. But of course, there are many instances where people don't get round to it. You know, sometimes due to the grief, sometimes because your affairs are not organized. So, due to many reasons, there is a delay. So, the fact that there is a delay in coming to court does not mean that you can't proceed with the testamentary action. You have to proceed with the testamentary actions, but of course, you will have to give reasons as to the delay. So, you can't just look up and wait for years and years. Sometimes it happens, but generally you are expected to come to court within 3 months.
And if, as you said earlier, the estate, the value of the estate exceeds 4 million and it includes immovable property, but the heirs fail to come to court and seek the assistance of court to administer the land, they can't deal with the property according to their whims and fancies, can they?
No, there is a prohibition against dealing with property without letters of administration being granted to someone to look into the affairs. But if you wait for 5 years, then it is not compulsory. But what would happen is, supposing you want to sell a property, then the buyers would question it, because till there is a testamentary case done, especially where a person dies without it. Say there are 5 children and 2 children want to sell it. So, the buyers would want to know whether all the heirs are aware, who the heirs are. So, all that is decided in a testamentary case. So, testamentary case, in addition to bringing in the property, would also decide as to who the heirs are, who is entitled to it. So, if you want to sell a property or deal with the thing, you will not have good title to deal with it unless you have got letters of administration.
So, it is actually to your benefit to go to court and be conscientious and be efficient, because otherwise you will come across various challenges when you wish to dispose of the property, isn't it?
Yes.
Madam, what would be the last stage of such a testamentary case in relation to property which has now in relation to intestate succession?
Yes. So, basically you would first go into court and set out the assets and all, and set out who the heirs are, and you would ask court to appoint somebody to administer the estate. So, once that person is appointed, that person has to first file an inventory in court. That is, you have to file a list with all the assets and the liabilities. Then that person has the task of balancing the two, to pay off the liabilities and to find out what is finally left. Then you have to distribute the assets in some way. So, sometimes like say there will be jewelry. So, you will have to decide as to how to distribute that jewelry. Property, when it comes to land, the title vests in the person immediately upon the death. So, say a man dies leaving 4 children, as soon as he dies, if there is no will, the title vests in those children. However, they can't deal with it legally without first filing this testamentary proceedings. So, after they file and once the letters of administration are issued to a person, then they can deal with the property. Yes. So, sometimes there are instances where the administrator will do a deed. If there are say 4 children, he will do a deed saying that the father died leaving this particular property, and that on intestacy it goes to 4 children. So, but it is not necessary for the administrator to execute a deed in order for the children to get the rights. They get the rights immediately upon death. However, now as you know, if you try to sell a property, people will go to the land registry to check title.
Yes.
So, in the case of a person dying without a will, nobody would know what happened to the property after that in the land registry. So, to safeguard your rights and to inform the world as to how the rights devolved, you have this testamentary case, and once it over, you do what you call an administrator's conveyance. So, then you register that in the land registry. So, for future generations, when somebody wants to buy, they know exactly what happened to the land. Otherwise, there can be a little gap in the land registry records.
So, your title is also secure then, isn't it?
It's clearer, because sometimes after 2-3 generations, you don't know what has happened. Whereas, if you have all these things recorded in the land registry, your title is better.
But it isn't necessary.
It is not necessary in the case of in any testamentary, it's not necessary. But very often people do it so that their title looks better.
Thank you, madam. Well, ladies and gentlemen, that is all we have time for, but I am most grateful to you, Mrs. Soumya Amasekara, for taking time off your schedule to be with us. I am sure our viewers found these few minutes extremely informative, and we are most grateful to you. That is all we have time for tonight, ladies and gentlemen, but do not fret. Next week as well, we will have a follow-up show on inheritance. So make sure to join us next week. Good night.